much welcome everyone, and perhaps then a specific welcome to our new participants. We're always glad to see the group going, and honestly, World Group is much about getting to know each other and working together. So most welcome everyone. What we did before this meeting was actually to make a shout out to the respective representatives of the group for interesting subjects to bring up in a future meeting. And AI was one of the topics suggested, and that is most welcome. And for everyone, just to know that we would very much appreciate on a continuous basis to get suggestions on whatever topics or initiatives you want to the group to take or approach. It doesn't have to be online seminars like this, but it could be topics where we could make a joint presentation or even more ambitious projects than that. But so please just firsthand perhaps email Hannah with a copy to me, Amalia, who is the head of the group for the Americas, and Jane Wang, who is the head of the group for Asia, if you have any such suggestions. Always welcome. Okay. AI then, or artificial intelligence. In the legal word, it's a bit trending, one might say, and it is very interesting to note that different jurisdictions take slightly different approaches to, for example, the patentability of AI-related inventions. So we haven't seen the end of that development, I'm sure. And I'm not to sort of steal the thunder from our upcoming speaker, but as food for thought, and to touch upon a subject that all us lawyers love, definitions. The rhetorical question can be made initially: what is AI? Is there anyone in the audience that would dare a quick definition or answer to that question? Well, I guess there is no unified definition, but the core is a system that is capable of activities which previously have been possible only to humans. Or to provoke a little bit, one could state that artificial intelligence makes humans less relevant. And when we talk about AI, we often refer to autonomous reactive systems that learn from experience or repetition. Or at least one reason for AI to be trending now is also in the legal world, is that the level of this autonomy has increased. And we are very thankful to the colleagues at our member firm in Poland, who has taken on to inform us about certain legal aspects relating to AI. And I will take up no more of the time, but let you introduce yourselves, because you will definitely do a better job in doing that than I would. So, Marek, over to you.
Thank you very much. Thank you for this warm welcome, and thank you, Hannah. I'm also happy to introduce quickly myself, Marek Olekson from Poland. I'm attorney at law, dealing mostly with patents, trademarks, and fair competition on the contentious and non-contentious angle. So that's what I do here at SKS in Poland. And indeed, I'll be happy to share with you some thoughts and some comments on most recent developments concerning certain aspects of AI, namely in the field of patenting inventions generated by or with the use of artificial intelligence algorithms. And that's exactly how you started, Per. It's a key, I think, an important factor to first have a look on how we should define artificial intelligence based on what we have, at least here in Europe, on the table right now. So just to start, I hope you can see the slide. And as mentioned, there are indeed many different approaches, both on the legal, financial, business perspective and IT, of course, as well, as to how we should understand and define artificial intelligence. And without going here into detailed summary of different views on this, I thought it would be good just to have a look on still quite a fresh paper from the European Commission with their proposal for artificial intelligence regulation. This document was circulated back in April this year. And there is an attempt to define AI system, which is very interesting, I think, because indeed it mentions that we should understand here a software which is developed with one or more of the techniques and approaches. Those are being listed in this document as Annex 1. And their purpose is that for a given set of human-defined objectives, this software should generate outputs such as content, predictions, recommendations, or decisions influencing the environments they interact with. So that's quite an interesting, quite a general approach the Commission proposed here. And I think that this very proposed definition did not bring so much discussions among lawyers and not only, rather than what AI techniques and approaches should be understood. And this is mentioned in annex to this draft regulation, because indeed those techniques and approaches are proposed broadly as well, because they are to involve not only machine learning approaches like supervised, unsupervised, reinforced learning, which use a wide variety of methods, but also logic and knowledge-based approaches. These should include knowledge representations, logic programming, knowledge bases, and also statistical approaches, Bayesian estimation, or search and optimization methods. So this proposed paper triggered lots of discussions as to how in practice and in the legal definition artificial intelligence should be understood. And we thought it would be worth sharing this definition with you on the slides, as it may also have impact on our subsequent discussions as regards inventions which will be made, created, developed with the use of artificial intelligence, perhaps in the meaning as proposed by the Commission in their most recent draft. So this is a few words about definition. And as regards European, let's say, approach and current path where we are with respect to patenting inventions made by artificial intelligence, this was a poll which we asked some businesses during our earlier presentation on this. We shared this with you not to let's say count the votes and check where we stand as regards answering those questions, but what is interesting is that 70% of the audience, mainly business, opted for option 3, and they mentioned that those inventions made exclusively by AI algorithm should be patented, and the patent should be granted to the owner of AI algorithm, whereas like 10% of the audience mentioned that such patents should not be granted at all. So this was quite interesting as regards asking business and technical folks about how they understand or they would like the patent system to work with respect to artificial intelligence. And just a question also to the business why this was important at all is that, of course, as regards our, let's say, legal playground, namely patents, this patents brings market monopoly, and in order to get such a monopoly by virtue of a patent, several prerequisites must be met. Not only those inventions should be new, involve an inventive step, and be susceptible of industrial application, but also, which I will mention in a second, some formalities should be met and observed as regards filing invention for patenting in different legal systems, not only before the EPO, but also in different national patent systems. So the issue appears to indeed be important, and the importance will grow, as there are just a few points which we should, so let's say, consider when we think about patenting AI-made inventions. So first, whether it is or should be necessary to indeed indicate the inventor in patent applications in different jurisdictions. Can artificial intelligence or should artificial intelligence fulfill the conditions of being a person who should be named as an inventor? And can the actual designer be something else than a human? And are these issues anyhow legally regulated at the level of the EU or other European countries as regards granting patents to inventions made by not humans, let's say, so by AI algorithms? So when we have a look at the EPO regulations, then we see that the European patent applications may be filed by any natural or legal person or anybody equivalent to it. And the right to European patent will belong to an inventor or his successor in title. So that's what the EPC says. But it also interestingly says that when you have a look that if by a final decision it is confirmed that a person other than the applicant is entitled to grant the European patent, then that person can, among others, request that the European patent application be refused, which we think triggers some practical consequences of granting or not granting patents to inventions where someone on something else than human is pointed out as an inventor. And this follows from Article 60, 61 of the EPC. But also, when we file the European patent application, we should designate the inventor. And in case the applicant is not the inventor or is not the sole inventor, we should indicate the origin of the right to European patent. And also, interestingly, in this designation, we should include name, surname, and address of the applicant. This follows from the implementing regulations. I share this background because it was the basis for the EPO to decide on, let's say, the most vigorously discussed case as regards inventions made by artificial intelligence. So the, let's say, renowned Dabus case, which was filed among others before the EPO. And when it was filed, EPO refused 2 European patent applications where a machine was shown as an inventor. This was Dabus, and it was indicated as inventor with respect to 2 European patent applications, and it was described as a type of connectionist artificial intelligence. Interestingly, in this case, the applicant stated that he acquired the right to European patent from the inventor by being its successor in title. And the EPO refused granting the patent, saying that this application did not meet respective EPC requirements, and the inventor designated in the application needs to be a human being, not a machine. And Dr. Taylor, who was the applicant here, he honestly mentioned in his patent application that it was Dabus, his developed AI system, who was the source and who actually, let's say, made an invention. So this is under appeal right now. We should expect the Boards of Appeal hearing somewhere in December this year. So we will see where it goes. But on the other hand, the same invention was filed by Dr. Taylor in other jurisdictions, also in the US, in Australia, but interestingly also in the UK. And we have some developments, very fresh ones from United Kingdom. And just a few words of background in order to get a better picture of how it was decided by both courts in the UK. So first, we see that under Article 7 of the UK Patents Act, right to apply for a patent is granted to every person who is inventor. And this inventor is defined because it means that it's an actual deviser of the invention, and joint inventor should be construed accordingly. But what is interesting and important in terms of the outcome before the UK courts is that there is quite an important Article 13 of the UK Patent Act, which says that unless this applicant has already given the patent office the information, an applicant for a patent must, within a prescribed period, file a statement where he will identify the person or persons whom he believes to be the inventor or the inventors, or otherwise, where the applicant is not the sole inventor or are not joint inventors, to indicate the derivation of his rights to be granted a patent. And this was actually the key legal provision which was subject matter of a dispute, both before the UK Patent Office and then also before the courts. As you may also see in the UK IPO formalities manual, there is already a learning saying that AI inventor is not acceptable, as this does not identify a person, which is required by law. And the consequence of failing to supply this piece of information is the application deemed withdrawn. So that's the, let's say, the legal background of the outcome before the UK courts. So the first decision was given 1 year ago by the England and Wales High Court of Justice judgment dated 27 September. And in that judgment, in that decision, the appeal brought by Dr. Taylor against the UK IPO decision was dismissed. And quite interestingly, the judge, Marcus Smith, mentioned in the decision that it is impossible to say that simply because Dabus has invented something and Dr. Taylor owns Dabus, then as a consequence, Dr. Taylor is entitled to the grant of a patent. So he mentioned that there must either be an application by the inventor within the section of Article 7 of this UK Patent Acts, or the inventor must have transferred the right to apply, enabling him to apply under one of the section 7(2)(b) or 7(2)(c). And eventually, his referral to the High Court of Justice was dismissed, but he filed appeal to the Court of Appeal, and the decision was issued most recently on the 21st of September this year, where by majority 2-1, that's also interesting, the appeal was dismissed. There are many very interesting considerations about the UK patent law and UK patent filings. So I put the link to this decision for you in case you would like to have a look on what was said by the three judges deciding on this case. Eventually, the appeal was dismissed, although it was not a uniform decision. And some of the observations which were made in this recent decision was that Dr. Taylor indeed failed to identify the person or persons whom he believes to be inventor or inventors, as was required by the UK Patent Act, this article, section 32A. And the judge also mentioned that Dr. Taylor deliberately consciously pointed AI as the inventor, and he did not identify the derivation of his right to be granted the patent. So in summary, the outcome of the decision was that since Dr. Taylor did not comply with either of the requirements which were laid down in the section 13 mentioned earlier, the inevitable consequence for his appeal was to reject, dismiss the appeal, and deem his patent application to be withdrawn. So that's the current status of the case before the UK courts. So we may also see some referral to the Supreme Court, but that's not the only case which is pending. During this procedure, he mentioned that in Australia he was granted the patent filed in the analogous case. So this, of course, brings lots of discussion about how the patent system should be structured in different jurisdictions to somehow address the challenges which appear to grow as regards making inventions with or by artificial intelligence. And just to name a few of them, we can discuss and we can consider what happens or what should happen if a human being is no longer a designer at all or to a sufficient extent, and which factors should be taken into account when we consider a human being as a designer or co-designer of an invention, whether he should feed the AI algorithm with some data, whether he should analyze the output given by by the AI algorithm, for example, whether he should be the person who actually developed the AI algorithm to be named as co-inventor. What should happen if the office comes to conclusion that this invention was made jointly by human and AI machine? And why is this important? It's important also because this inventorship issue is not only, let's say, one of the formalities to be ticked in patent application, but it also determines ownership and effective IP rights assignment as regards subsequent ownership of a given patent. And this can also impact validity of a patent granted. And in turn, of course, dependent on where we go as regards the practice or perhaps the new rules for inventing, for patenting inventions made by AI, this may, let's say, strengthen or weaken motivation to develop inventions with the use of AI. And perhaps we can also consider businesses' tendency to lean towards trade secret approach rather than making inventions disclosure to the public. So these are just a few remarks on a very broad and, of course, vigorously discussed patenting AI inventions in Europe. So we are very curious to see how the matter develops before the EPO, in the UK, of course, as well, in the United States also. And yeah, and we are also very happy to hear your thoughts and comments on that and observations on, of course, this constantly growing, interesting topic. Thank you very much.
Well, thank you, Marek, very much. Any immediate reflections from someone else in the European community on what Marek said? We will have opportunities for other comments later, but no. Then Jane and Amalia, I don't know if you have encouraged someone specific to comment from the perspective of the Americas or Asia.
Well, looking at the Canadian approach, where I'm from, for those who I haven't had the pleasure of meeting in person, I'm Amalia Berg. I'm based in Toronto at Goodman's. So in Canada, it's a very interesting time because in July, our federal government actually launched a public consultation on what we do in Canada and looking at perhaps adapting Canada's copyright framework to address these ongoing developments. And so it's quite timely because Canadian stakeholders had until mid-September to provide comments as to where we're going to go. And a consultation paper was launched. So, you know, one of the key issues obviously was the one that you touched upon in terms of authorship and ownership of AI generated or assisted works, because our Canadian law contemplates ownership by a living human being. So different approaches are being considered, and it'll be interesting to see where we land.
And perhaps a comment from my side as well, Julia from Taylor Wessing also. As far as I'm informed, there had been 2 decisions in favor of a patent. So for the time being, it's 3-2 for and contrary patent of artificial intelligence. As far as I remember, it was in Australia, it was a positive decision, but I do not remember the other country.
Yes, indeed, Julia. I think it was also in South Africa, as I may recall, if I'm correct.
Yes, Marek and Julia, it's Hugo here from South Africa. I can confirm that the other country you're thinking of, Julia, is South Africa. But maybe just some background from my side on that particular decision. So the South African one is actually quite interesting because if you go and look at that case a little bit critically, you'll see that the Patent Office didn't actually have to consider the substance of the issue, whether AI can validly be listed as an inventor because of a technical or a formal ground. So in South Africa, and I don't want to bore you with technical details, but I think it's important. In South Africa at the moment, how it works is if you file a PCT national phase patent application, the requirement to provide an assignment or to explain the entitlement of the applicant to apply is dispensed with if the applicant in the priority application and the applicant in the PCT application was in fact the same entity. So in other words, the Patent Office issued a rule, I think it was about 10 years ago, saying they are happy to dispense with the requirement to file an assignment if the priority applicant and PCT applicant were the same entity. So, and in this case, in the DABUS application, that was in fact the case. So the applicant listed on the priority application was, I believe, Dr. Thaler, and the same applicant was listed on the PCT application. So by virtue of that formality, the Patent Office didn't require any sort of proof of entitlement, and they didn't consider the AI issue, I believe, on its merits, and they just granted the application. So it's true that the application has been granted, but I think the issue has not been resolved in South Africa. We still don't have legal certainty, and I think what will probably happen is this will have to be determined by a court. So this grant, or maybe a future grant of a similar patent, will in all likelihood be challenged, and then we will have to see what the courts say about this practice. But that's just from my side some background, and if anyone has any other questions on the specifics of what happened in South Africa, feel free to reach out to me. Thank you.
Thank you, Go, because this is Jane from Taiwan. The DABUS case is very interesting, and I was so curious about why it can be granted a patent in South Africa. And after your explanation, now I know some like technical reasons. Because in Taiwan, we also have the DABUS patent application, and just at the end of August this year, the court has rejected the patent application. And the reason is pretty much the same as in most countries, because the court believes that patent should be granted to a person. So it's so interesting to know that in South Africa, it's not because of whether DABUS is a person or not, but because of those specific procedural reasons. That's so interesting.
Yes, Jane, just to add on to that, so the Patent Office, they weren't required to consider whether an inventor can be AI or not. And if you actually look at the South African patent laws, in terms of their wording at least, they're very close to the European and UK patent laws. They don't specifically state that you need a human inventor, but I think similarly to the UK, when you read the law, you read the act, you read the forms that you need to fill in, it very strongly implies that the inventor has to be a human being. But as you pointed out, because of this, absence of requirement to show entitlement, the application went through the system, and we'll have to see how the courts interpret it.
Yeah, it will be interesting to see if this Dr. Talens has the funds and resources and ambition to actually uphold his patent against someone. Then we will really see how that stands up to any revocation actions in answer to such an infringement allegation. I guess we don't have anyone from Australia online, right? That would have been interesting, of course. I don't know if anyone...
A little late for them, Per.
Yeah, probably. Yeah. But those were interesting reflections from everyone. Thank you. Are there further comments from someone on the topic? I guess not. Then just well, a brief reflection perhaps from my side is that I would presume that this, of course, has been a little bit of a try and seek or provocative action of the applicant here to actually try the system, because as we saw from example the UK remarks from the judges there, there were perhaps possibilities for him to save his applications if he would have argued along the lines of him being the inventor as he has created the AI system and so on. He didn't, and you can speculate in why he did not. If this was actually his 15 minutes of fame to get to try the system, but I am also presuming that we would see such a development because we can probably all relate to the fact that many inventions, many patented inventions, obviously to a very large degree depend on different types of, well, let's say machine assistance and computerizing and whatever means you have to arrive at certain findings. So I guess AI is a tool for that, just as any other tool, and patented or inventions that are patented by the use of such tools, we will probably get patents for. And so to some extent, it feels a little bit like a theoretical question, because we already know that in the patent laws of many countries, I will not claim to know overall, there are already restrictions on mathematical methods being patented explicitly. Those are taken out of the patentability. And what is an AI if not a mathematical method of actually arriving at something? I don't know. But if there are no other comments.
One more comment from my side.
Yeah, sure.
For example, in Germany, you can't get a patent for a computer program. Just contrary to the US. So we have here some discussions between patent lawyers of the US and from Germany, and no side understands the other one. And I think this leads a little bit in the same direction.
No, I agree. I agree, Julia, and then that is the same for many other jurisdictions, taking the sort of same approach as Germany does, but rather allowing patents on what is the result of the use of such a computer program.